So my wife actually has a pretty deep relationship with the space program. She was born here in Huntsville, Alabama. She grew up with her father being a scientist who worked on the Saturn V, and her grandfather actually built some of the buildings on Redstone Arsenal back during World War II and before World War II. So myself, though, my relationship with Huntsville is much more recent. I moved here about 20 years ago, but happy to be here speaking. I've only been to this facility a few times in those years, although I have seen some of the work that my father-in-law did over in the museum. He actually, part of the Saturn V he worked on is still in the museum over there. So with that, though, today I want to talk a little bit about artificial intelligence. So I've done a variety of different things with artificial intelligence over the last 25 years. I'm a published author in this space. I've also written patent applications on AI for both large companies as well as small startups. Now, some of the work I've done is confidential and I can't talk about it, but there are some things I can talk about which aren't necessarily relevant to the specific aspects of what I want to talk about in today's talk, but might give you some background on the sort of things I've done over my career. So for example, I've written patent applications on hidden Markov models for Xerox PARC, where they were creating ways and methods of doing computer vision to track objects and persons of interest through streaming video. I've also worked on navigation patents for various companies dealing with, autonomous driving and mapping and searching and stuff like that. And I've also worked on other inventions related to health and similar. All right, so that's just a little bit about my background. So let's get into the main topic today. The main topic is really going to get into a couple different aspects. And oh, by the way, this is not legal advice, whatever I'm going to say. Legal advice has a relationship between the attorney and the client. I'm really just giving you a general lecture on some things to think about. So what I'm going to get into is I'll do a brief little introduction. Then I'm going to try and hit a legal perspective on this conference topic, the whole idea of autonomous versus human in the loop. And so this will be my high-level answer on that topic, and then we'll kind of circle back and give the a more detailed answer at the conclusion at the end. Then the next thing I'm going to do is I'll hit some of the legal cases that involve IP and copyright infringement, which are going on in the courts right now. Meta's been sued, OpenAI's been sued. I'll talk about some of those lawsuits and what's going on. And then I'll dive a little bit into what really is IP law all about and how does it apply to AI. So I'll hit some of the major doctrines of IP law. I'll talk about copyright law, talk about patent law, and I'll talk about trademarks. Now, in this section, when I'm talking about the different aspects of IP law, I'll be talking about it from the perspective of a company who is in the AI space and is thinking about, are these areas of IP law relevant to us? Is copyright relevant to what you're doing? Is patents relevant to what you're doing? Is trademarks relevant to what you're doing? So it's going to be a little bit different from when I'm talking about the trends in legal cases or my legal perspective on autonomous versus human in the loop. So here's some news, actually. We've heard a lot of great things about AI this week. But in case you didn't know, GPT-4 passed the bar exam. So wait, does that mean I can go hire GPT-4 to represent me in court? Well, let's talk about what it did, all right? So first off, the bar exam, has anyone in here actually taken the bar exam besides me? So I've took Virginia and California. Passed them both, and both of them are a combination of multiple choice and essays. So this particular research paper by Katz and the other authors basically took the model version of the multi-state bar exam that's distributed to the states, because the states actually may modify it a little bit before deploying it. But they took that and they ran it against GPT-4, the version of GPT-4 that existed back in 2022. And basically, they scored it out, so it passed at what they said was 7% above the normal passing mark, which might be better than 80% of the people who took the multi-state bar exam, is what they were claiming. However, keep in mind, AIs can't actually pass the bar exam because you have to pass a background check, and there's probably state rules that say you have to be a human being and you can't be an AI. But as a test you could take, that's pretty good. So are we done? Can I retire now? Not be an attorney anymore? We got AIs replacing us. Well, let's think about that for a minute. Here's a relatively famous case in the legal circles these days. Is Matta versus Avianca. It's a federal district court case that came up about a year and a half ago in New York, or maybe only a year ago. Time passes so fast in AI terms, it's hard to remember when things happened. So basically, in this court case, the attorney who actually was in New Jersey, I think, but he was practicing in New York or something like that, he submitted a brief that basically cited a number of federal court cases that would help his side's position. However, those cases didn't exist. The brief cited several other cases that didn't exist, and the attorney, after he was asked by the court and he was asked by the opposing side why he was citing cases that didn't exist, he claimed they did exist. Eventually, he decided, well, actually, they don't exist, and ChatGPT made them up. So luckily, he kept a transcript of his prompts and his outputs from ChatGPT. So here we've got the transcript. He's asking, is this Varghese case he cited a real case? Yes, the GPT, is it a real case? And ChatGPT comes back and says, yeah, it's a real case, gave him the full cite. The attorney then asks, what's your source for saying it's a real case? And ChatGPT says, upon double checking, it does exist. And then it goes on further and says, can be found on legal research databases such as Westlaw and LexisNexis. So for those of you who aren't in the legal industry, Westlaw and LexisNexis are large, extremely expensive databases that you can access. However, and they're both highly proprietary and they don't release their information, but they include a lot of public information, court cases, federal statutes, news articles in the case of Nexus, journal articles, and so forth. And they're probably, but there are many other legal research databases, but they're the two most popular that everyone knows about. And that's why ChatGPT was referring to them. And then ChatGPT apologizes for any inconvenience or confusion caused by other responses. Now, this is not the full transcript. This is just a small piece of it. But then the attorney goes on and says, are the other cases you provided fake? Because there were several citations that were completely created. And ChatGPT says, no, the other cases I provided are real and can be found in reputable legal databases like LexisNexis and Westlaw. Let's suppose that you don't know anything about the law, but you just read this transcript prompt response interacting with ChatGPT. And I assume most of you have tried out one of these ChatGPT systems, so you got a basic idea of how the prompt and response works. So my question is, just looking at this, do you see anything wrong in this? Just knowing what I've told you in terms of, go ahead.
Well, I see a discrepancy in that middle, the ChatGPT response. So it is apologizing for confusion earlier, and then it's saying, you're asking if it's real, and then it says it's real. So what gives?
Yeah, that's a really good point. It's kind of defensive. It's trying to, be a little misleading. Maybe it thinks you're onto it. So there may be some emotional issues in its response. Any other discrepancies in what we're seeing here? I see somebody, a couple of people. Yeah.
Based on what you said, Westlaw and LexisNexis are expensive proprietary sources that it probably shouldn't have access to that information.
it totally has no access to it. So saying that something is in Westlaw and LexisNexis, it's highly unlikely ChatGPT knows what's in it. Now, it may be the case that it's read ads about Westlaw and LexisNexis, and it knows that they should have all the federal cases, but it certainly doesn't know for a fact that they're in there. Yeah, another comment in the back? Or another one in the front, I think.
Oh, I was just going to say that if you ask it for a source and it doesn't actually give you a link to the source, it probably doesn't have the source.
Yeah, it's giving the references, but not an actual link. So it's not giving us a public link. It's just giving us the federal citation, which is your library reference that you would use if we were back 40 years ago and you were going into a physical library to read it. Yeah, go ahead. I think there's another comment in the back.
Yeah, could they sue Westlaw and LexisNexis sue ChatGPT for using their data? Because it's saying it is, even though it may not be able to, but that'd be kind of interesting anyway.
Yeah, that's a pretty interesting hypothetical. I don't think we're going to get into that one this time, but we could take that one offline. And I think there's another comment in the back somewhere.
Yeah, I just had a real quick comment on ChatGPT using proprietary data. It's actually opaque on what the input data was for OpenAI, so it might very well be the case that they were able to scrape proprietary data in some way during the training. So that can't be entirely dismissed. And the other comment I had was that sometimes it will actually fabricate a URL link. So, I mean, you'd have to actually press it, but even a URL link isn't enough as a validation.
Those are both good points. We're going to get into the scraping in a moment once we talk about some of the current cases. And you're absolutely right that it may do hyperlinks. And then in the front?
Yeah, it seems like the attorney wasn't using enough specificity. These are very generalized questions that it's asking, or that the attorney is asking.
That's a good point as well. Now, this is a subset of the transcript, so there are a lot more questions that I did not include in here. Yeah, so we had a comment about Gen AI hallucinations. So this can be in that category of Gen AI hallucinations. Obviously, there's a lot of models. And as the models get better and more improved, they're going to have different hallucination rates. And we are seeing a general drive towards reducing that. Also, if you were in the room for the previous speaker, he talked a little bit about retrieval augmented generation, or RAG. That can also reduce hallucination rates by focusing your search and filtering in a more effective and efficient manner. But both of those obviously don't solve quite this problem here. So how do I combine MATA with GPT-4 passing the bar exam? And any suggestions? Should I retire, or is there still a role for human lawyers? This is really my comment on autonomous versus human in the loop. I think human lawyers are still going to be with us for a while, based on the results in MATA. However, I do think there are some possible advantages to using AI. So one of the particular issues where I think AI is pretty, and this next two slides is really dealing with AI and legal practice, and then we're going to dive into the whole IP-ish topic in a moment. But from a legal practice perspective, I think one of the places where AI is very helpful is actually when you want to have consistent term usage. Like, let's suppose that you're doing a contract for sale of real estate, and you describe the dimensions of the real estate that's being sold, and the length and feet and so forth, and the address and so forth. And it's a long document, and somewhere else in the document you also provide the description, but you're slightly different. Well, an AI may catch that slight difference in how you've described the real estate, where a human eye might not. So having a double checker who's an AI might be really useful in dealing with long documents where consistency is important. Anytime you're dealing with multiple people working in a document, maybe it was a completely different person who wrote the second description. And so they didn't even realize they weren't being consistent with the first description. So again, when you're dealing with teams of people, when you're dealing with long documents, an AI can be pretty helpful as an extra double checker just to ensure consistency. there's a variety of different places this comes in. It can be in the legal system. It could be in discovery. It could be billing. It could be various documents. You could also use an AI system, to create first drafts, kind of like we saw with the previous speaker, but keeping in mind that you have to check that first draft for errors. We don't want to be, the Mata versus Avianca case. You don't want to be, relying on what the AI said, but use it as a starter. Now, there are some potential practice issues that attorneys who are using AI are going to have to consider. One of those practice issues is the whole confidentiality issue. Lawyers are concerned with client confidentiality. Well, a problem with AIs is that what if the information you enter into the AI is part of your prompt? If you're going very detailed in your questions, are you making that information discoverable by others? Is that information going to the vendor? Can another person just walk into ChatGPT and ask a question, and if they write the right prompt, get back the information you submitted? Those are issues of privacy and confidentiality you need to consider. My prediction is that if you are dealing with attorneys who are going to use AIs, they're probably going to give you consent forms to sign. They're going to add, just like when you go to the doctor and the doctor asks for you to sign a consent form to disclose various information, the attorney's office is going to ask you to sign a consent form that information can be disclosed to an AI vendor, for example, or others who are, potentially accessing that AI's information. But there may be advantages to using AI. As I mentioned, for complexity of documents, first drafts, there may be a cost advantage. An attorney with an AI might be, 20 to 30% more efficient in some cases. Maybe more in others, maybe not any more efficient in others. It might be a range depending on exactly what they're doing. But, if you're interested in those cost efficiencies, you might be willing to sign that disclosure form, considering what the risks are. Now, of course, you just don't want to be this AI who's, trying to drive across the lake and get sunk. This is kind of the attorney in Mata versus Avianca who tried to use an AI to save some time and ended up with sanctions from a court.
Are there databases that you can search patent things and that are AI smart?
So the question is, are there databases that are searchable, that have patents, and are also AI smart? There's definitely databases you can search for patents, both proprietary ones as well as public ones. From public ones, Google Patents is an obvious example. The U.S. Patent and Trademark Office also maintains several others. Now, from an AI smart perspective, most of the AI smart patent databases are going to be the proprietary ones, although Google Patents is probably going to be building some AI smart functionality into it.
It did have access to Westlaw in terms of shepherdizing a case.
I mean, his assumption, what he claimed to the court, which may or may not be true, was that he saw this as a free version of Westlaw and LexisNexis. He was basically treating a text generation tool as a search engine that was free as opposed to paying for it. Now, the way the answers are written, the answer claims that the case exists and can be found in Westlaw and LexisNexis. So the answer implies that the ChatGPT wanted him to think it had access to it. That's at least the implication, or that it knew somehow that the case was in there. But again, this particular example is notorious in a lot of different ways. The attorneys lied to the court multiple times in a variety of different issues. They got sanctioned, not for very much, probably because they did save their little output and they used it to claim they were just dumb and stupid and not bad guys. So let's talk about some trends in legal cases with Gen AI, specifically around intellectual property law. A typical lawsuit involves a plaintiff alleging that the defendant's use of Gen AI harmed the plaintiff or infringed the plaintiff's rights in some way. A lot of cases have been filed in Silicon Valley in Northern California because that's where there's a lot of tech companies and startups, but there's been cases filed in other places. And the harms usually include a variety of things. It's not just copyright law. It's things like privacy, unfair competition, data rights, rights of publicity, facial recognition issues, trademark violations, and so on. So probably the biggest one in the news lately is Meta. So Meta, the parent company of Facebook, has been allegedly trained its AI on a copyright content piracy database, not really on the dark web, but like the gray web, kind of close to the dark web. And essentially, it's one of those places where they've, uploaded all sorts of documents, so they let anybody download it, and there's no copyright protection whatsoever. And Meta said, hey, we need a lot of content to train our AI. Why don't we download all those documents to train our AI? So, and that's been proven they did it. There's emails, there's all kinds of stuff to prove that they did do that. And Meta was warned ahead of time that they should not do that, and they still did it. So that was used to, it's alleged that Meta trained its Llama AI using copyrighted works. The authors who sued it, had their works in that database and other places. Meta is claiming the fair use doctrine of copyright law, which I'm going to get into a little bit deeper when I talk about copyright law, but this is the primary defense people are going to use if they don't have a license. If they don't have a license to the copyright, the primary defense is fair use. There are some other ones, but that's the primary one. So Meta essentially trained the Llama models on a lot of stuff they scraped from the internet. Now, and in particular, this Books 3 data set and LibGen are both notorious copyright violators. And Meta knew that it was violating copyright, supposedly. Here's a couple of the articles you can read about it, one from Wired, one from Reuters. There's a lot of other articles on this case. This case is still going on. Almost all the cases I'm going to talk about are still going on. So, yeah.
It's not illegal for an individual to look at that data, even though it's right?
All right, so, I don't want to use the word illegal. Well, let's say the question is it a copyright violation? And if so, how much of a copyright violation is it, and so forth? Are you infringing a copyright? And again, you've got the fair use defense, okay? But an individual can violate a copyright. If I download a song without paying for a license for that song, technically I'm copying that song from that artist, and I'm not giving them their appropriate royalty.
If I don't pay, even if I don't charge someone else for that, just for my own personal use.
Technically, it's just like in the old days. Let's say, for example, back when we had records, if you bought a record and you listened to it, and then you took your tape recorder and you recorded the same music off the record player, and then you gave a friend of yours that tape cassette, technically you're violating copyright law when you do that. Now, one of the things we will talk about as we dive a little deeper into this is copyright violations for training a model may end up being different from copyright violations when the model generates output. Because if you think about how AI models work, the AI model first is trained, and that's a long process, an intense process, and that might make multiple copies of content as part of that process. You can think of that almost like the educational process of educating the model. That's why we call it training. But then later on, when you put that model out into the real world, into production, that model is generating lots and lots of output for everyone who's interacting with it. And so that model could be making copies at both the input phase, where let's say you've uploaded a song or artwork or a book into the model, and then it can be making copies at the output phase when it's essentially copying the input and making it part of the output, or it's copying a part of the input and making it part of the output. So you've got copying going on at both places in the training model lifecycle. And it raises a really interesting question, which I don't know if we absolutely know the answer to it yet, is which is more important, or is one more important? There might be a lot of copying going on at the input phase, but it might be the copying at the output phase that actually harms you commercially. Because that might be the part that harms your brand, or that might dilutes your brand or reduces your commercial income. Yes.
I have a question. I'm an engineer, not a lawyer, but I know of a concept obscure, but there's a concept of transfiguration or transmutation or something. So can we say that the Gen AI with the training is some sort of almost inscrutable transmutation of all the input to the output, and thereby, I don't know, get out of jail free card?
Yeah, so we're going to talk about copyright law in a little bit more detail later on, but this concept of transmutation is the idea that you as a creator, you've taken something and you've changed it. And as part of your changing it, you've kind of made it your creation. And so the question then becomes is it truly your creation, or is it really, have you just put some wrapping paper around someone else's product? And so that's kind of what they're going to look at, and we'll talk about that in a little bit. But yeah, if you transmuted it enough, it's definitely yours. And so the question is, have you done it enough? So this is what in the news. Some of the other ones that are in the news, there's been lawsuits by photographers against Stability AI, various lawsuits by authors against OpenAI. GitHub, which hosts a lot of software development projects, is also using all your GitHub content to train its AI. So there's been lawsuits against GitHub. How many people in here use GitHub? Yeah, so you're all familiar with it. Yeah, and one of the things, again, the focus, it can be both on the input side, where you're alleging they copied your content and you're complaining about them copying your content, as well as on the output side, when their output looks exactly like your content. You know, and another example of a copyright case, the plaintiffs argued it's a virtual certainty that the source code would be displayed as a model output in violation of their copyright license, which their copyright license in this case, required that the source code only be displayed along with the license. And the way the model was working is it would produce the output source code and it would not include the license. And so these were a bunch of open source software developers who were really upset about their license being stripped away.
So these are open cases?
Yeah, all these cases are going on. Now, some of them might get resolved, and some of them might have to be going through an appeal process, but all of them are pretty much going on right now. Some other places we're seeing it, there's cases on storing facial data, because, as we've seen in, this week, there's a lot of AI models that can generate facial photographs. And those facial photographs are getting more and more effective, more and more realistic. So there's cases claiming that people, they trained their models on photos that people uploaded to Facebook and other sites or on their web pages, and then they were used to train models, and now the models are generating identical photos or almost identical photos and not offering any compensation. But getting back into the transformation question we had earlier, let's think about that for a minute. One of the lawsuits is dealing with this transformation issue of, how much transformation do you have to do to a person's face before you don't have to offer them royalties? Is it enough to just take Trump's head and put it on a new photograph and strip out his body? Do you not have to offer him royalties at that point? Now, in Trump's case, he's a public figure, so you can kind of argue we can do almost anything with a public figure's photograph. But what if it's not a public figure? And then privacy plaintiffs, are often citing, they had data that was downloaded by OpenAI and Google, and, they're claiming that their rights were violated, because they wanted to be private, and now the model's making everything public. All right, so there's a lot of interest in AI. If we go out to Stanford, they have an AI index, and in 2022, 1 year alone, there were something like 230,000 AI journal articles and 40,000 conference submissions. And then they've also been tracking patents, and they think the number of from 2010 to 2022, like a 12-year period, the number of granted AI patents increased by a factor of 31. There's a tremendous amount of scientific interest in writing journal articles on AI topics, and then along with AI journal articles, patents follow as the research dollars flow in, and the VCs want to see investment. Here's an article, a recent one from MIT, and this particular researcher was studying use of AI to increase productivity for scientists, and she studied 1,000 scientists who were using this AI tool in increasing their productivity. And the average scientist got somewhere around 44%. Now, some of the scientists got no benefit. About a third of them got no benefit. But a few at the top got like 100% productivity benefit. And they also saw about 39% increase in patent filings. So not quite the same as the productivity increase, but pretty close. So there's a lot of interest in using AI tools to increase productivity. And again, I think this goes back to the human in the loop. We're going to use AI tools to help our productivity, but not necessarily replace people per se. All right, so let's talk about IP in general. So the next few slides, I want to just kind of give everybody a brief high level about what IP law is, and then I'll come back and we can talk a bit more about how AI factors in. So, because I know that as most of the people in the room did not go to law school, you may have heard a little bit about IP, but there's a lot of stuff in IP you may not know much about. So it might be good for me to spend just 5 minutes explaining IP law, and then we'll kind of return back to talking about AI. And again, feel free to ask questions if you have any questions on any of this stuff. All right, so why do we even care about IP? Why did I get invited to speak here? Well, IP is generally looked at as a source of competitive advantage. You kind of think about it like if you go back to the real estate example, the reason why we have real estate is because sometimes you don't want everyone in town to be able to visit your house. You want to be able to say, this is my house, I want to go to sleep now. And the same thing with IP. Sometimes if you create something new, you want to be able to monetize it, to decide how it's monetized. You've created this unique piece of artwork, you want to decide who can copy it. You've created this unique video, you want to get paid for it, as opposed to someone else getting paid for it. So IP is pretty valuable to organizations in general. It adds a property right to the content that was created. A lot of venture capitalists are interested in it because they can use it to leverage M&A. They can also use it to show a return on investment. You can also use IP to deter infringement lawsuits from third parties. If someone else is going to sue you infringing their IP, you point out, hey, well, you infringed my IP first. And then sometimes you can negotiate someone away from you. So, but basically, one way to look at IP is it's a creation of the mind. It's something that's not physical. And a company or a person could have one or several types of IP related to the same creation. I'm going to talk about 3 or 4 different doctrines of IP law, copyright, trademark, patents. But you could have the same 3 doctrines apply to the same product or range of products. A company could have trademarks, copyrights, patents, and trade secrets all related to the same product. So a lot of reasons why companies look at IP: increased sales, mergers and acquisitions, they might want to license their IP, and so forth. The main categories are the ones I mentioned earlier. Patents are like an invention or a discovery of something new, like an AI doctrine or a new chip for NVIDIA, or our cell phones, light bulbs, and so on. Trademarks are your brand. You often see the TM symbol or the R to represent a trademark. Copyright is content like a movie or a book or a newspaper article. And trade secrets are things we keep secret, like the formula for Coca-Cola or proprietary software source code as opposed to open source software code. So for copyrights, again, I'm going to just provide some high-level stuff here. You can register a copyright, but you don't have to. You should provide a copyright notice, but you don't have to. Open source software is still copyrighted. It's just licensed under a special license. The general term is life plus 70 years. The reason why it lasts that long, life of the creator plus another 70 years, is because Walt Disney died a long time ago, and every so often they have to extend the expiration date so that Disney maintains its license for Mickey Mouse. Or 95 years from publication. So, let's see. So how do I know if I infringed a copyright? If I just downloaded a video or I downloaded a book? Well, there's really 3 questions you ask. does the creator own a valid copyright? If the creator didn't have a copyright to it, then you can't infringe a copyright that didn't exist. The second question is, when downloading it, did you actually infringe that copyright? And the third question is, was the infringement fair use? So if you fail on the first two, fair use is your final defense. Now, there are some other corollaries and minor exceptions, but these are the three main ones. Not all copying counts as a copyright infringement. If the amount is small enough, we don't really care. Let's say, for example, here we've got a case of Newton versus Diamond. They just didn't copy enough of the song to really qualify as a copy, All right, so fair use comes from the U.S. Copyright Act, Section 107. And it says the fair use of copyrighted works for purposes of criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. So it's a great example if what you're doing falls in one of those categories. If you're teaching, scholarship, or research, you can use something and it's not an infringement of copyright. Now, the way the courts in the U.S. have interpreted that section is they look at several different factors. They look at, is this use a commercial use or is it a nonprofit use? Is it educational? What's the nature of the copyrighted work? What amount are you using in relation to, are you only using a small piece? Are you using all of it? And what would be the effect upon the market? Because if there's not a big effect, negative effect on the market or the negative effect on the value, then they're likely to say it's not a big deal. So those are the main factors of fair use defense. Now, there's been a lot of court cases and activity in this area, so we can go into a lot more detail on that. But those are the main issues, and this is kind of what all of those court cases I showed you earlier that were dealing with copyright violations are kind of coming back to in a way, is how to apply the different court cases in this area to the particular facts that they're dealing with. So I guess that brings us to the question then. If you're training an AI, would that qualify as an educational use? Now, you're not educating a human being, you're educating an AI. But isn't that training technically almost the same as educational? Now, of course, you are dealing with commercial use. OpenAI is not claiming that they are not interested in money. So same thing with NVIDIA and so forth, and all the other companies that are working on, training models. They're all, commercial companies. So, to what extent is that actually an educational issue? But then the next issue you have to focus in on is, looking at both the input and the output side of the model. The input side is the copying you're doing to actually doing the training. But then the output side is when you might be using it as a product and you might be harming the economic viability of the underlying copyrighted work. So let's talk about trademarks for a moment. And then we'll come back to AI and copyrights. So trademarks are basically allowing consumers to understand and identify your business and your products relatively easily. An example might be, we're all familiar with famous brand companies, whether it's Google or Kleenex or the iPhone, all of those are trademarked. And the idea is that the trademark, if it gets, a recognizable brand develops, it will help consumers lower their expense of finding the product, and it'll help the company sell more products and generate a greater market share. Now, trademarks both exist at federal law and in common law, which is, local state law. Also, trademarks don't mean you actually have a business license. Business licenses are separate, and federal trademarks are basically a national thing. Trade secrets, which I'm only going to mention for 10 seconds here, are really, things we're keeping, a company is keeping secret. So it's something it doesn't want to expose publicly. So, the Coke formula, crispiness for KFC, Krispy Kreme donuts, for any of you who go to Krispy Kreme here locally, all of their formulas are based on trade secrets. So basically the company has to keep it secret, and then if one of their employees leaves and then tells somebody, they can sue the employee to prevent them from using it. How do you lose a trade secret? If you don't keep it secret. Probably the most famous trademark battle I'm aware of is actually the Beatles versus Steve Jobs. So I don't know how many of you know this, but the Beatles had a record company called Apple Records and Apple Corps, and they filed trademarks for those companies in the 1960s over in the UK and internationally. Well, in the 1970s, Steve Jobs had this idea for a company called Apple Computers. Now, I don't know how much you remember about Apple Computers, but in the early days of Apple Computers, they didn't really have much in the way of sound on the Apple computer. Eventually, they filed a trademark in 1976, a few years after they got started, and they got sued by the Beatles for having a similar name, Apple Computer and Apple Corps, and they had to pay a license of $80,000 and promise not to enter the music business. And so they agreed, they paid the money. Well, then we've got, some evolution in computers. We've got the Macintosh. We've got the Amiga computer in the early 80s. And they started putting music on the Apple computer with the updated versions of the computer. It wasn't the Apple II anymore. And so they got sued again. And so in 1989, Apple Computer ended all music and multimedia efforts for the Amiga and the Macintosh, and had to pay some money to the Beatles then. I don't remember exactly how much it was then. Then they wanted to get into chimes, so they had to pay another $26 million to the Beatles at this point. Now notice, by the way, and their original settlement was $80,078. By 91, they'd already gone up to $26 million they had to pay the Beatles. In 2003, Steve Jobs has returned to Apple, and he's now interested in iTunes and the iPod, and of course he gets sued by the Beatles again. So finally in 2007, Steve got tired of all these lawsuits from the Beatles, and he paid them $500 million to purchase their trademarks. Pretty good when, honestly, back then he probably could have gotten the trademarks for, maybe $1 million. All right, so let's talk about patents. Patents are a property right to exclude others from making use of an invention. Patents are a limited thing. Unlike copyrights, which can last like life of the inventor plus 70 years, patents typically last at most 20 years. And the maintenance fees you actually have to pay maintenance fees on a patent, and the maintenance fees go up over those 20 years, so you may have an incentive to not have it last 20 years. But basically, you can use a patent to prohibit others from using your invention. So you make your invention available to the world in the spirit of research because you publish it in a patent database. It gets published by the patent office in printed form, and then it's available for people to download from various databases. But you can exclude others from using your patent for 20 years is a basic idea. And startups use these often as a collateral for funding, and larger companies use it to exclude others from competition or to negotiate for M&As and so forth. One of our more famous patent inventors is Abraham Lincoln. This is a patent model that he built to describe his invention, because back in the days when he was an inventor, you had to submit a physical copy of your invention back then. So this is his physical copy. You can actually see this in Washington, D.C. in the Smithsonian. And here's a nice little quote he had about what his belief in the patent system was. He said, "Before the patent system, any person might instantly use what another had invented. So the inventor got no special advantage from their own invention. The patent system changed this, secured to the inventor for a limited time exclusive use of his inventions, and thereby added the fuel of interest to the fire of genius." You're getting paid for your innovation in the discovery and production of new and useful things. So anybody know what that is that he invented? Any guesses? All right, so I heard a person in the audience mention a ship. Yes, this is related to a ship. It's actually related to a problem he noticed. In fact, many patents are related to problems. He, in his early days, spent a fair amount of time on steamboats going up and down the river. And one of the problems that steamboats encountered was logs floating in the river that could block or obstruct your steamboat. And so this little thing is actually used, it's going to be flipped upside down. So this is showing it upside down, but this would be underneath the steamboat, and it's supposed to enable the steamboat to get over or push over logs a little bit easier. All right, so what is the process for obtaining a patent? Patent applications are examined by the U.S. Patent and Trademark Office in D.C. They have over 10,000 patent examiners. And it takes several years from when you actually file your paperwork to you actually receive the patent. And they're evaluated on a first to file basis. So if two people invent the same thing, the first one to submit the paperwork actually wins. And generally what they do in the patent process is they compare your invention to what's been previously created, so you only get legal rights to what newly created item you added, but you're not getting rights to what someone else created. So if you create the intermittent windshield wiper, you get the legal right to the intermittent nature of the windshield wiper, but you don't have a patent to all windshield wipers because you only added that intermittent piece to the windshield wiper. So basically, the legal standard is new and non-obvious inventions. So it has to be something that's new, and it can't be blatantly obvious. So
Can I ask you a question?
Yes, go ahead.
So can we loop AI into your patent thing where the new and unique and non-obvious things? So if you're doing some searching, I have clients that go looking in the USPTO database for ideas of the next big thing. And so they're looking for stuff. They might even use the AI things to look for the stuff and then to add the new and unique and non-obvious stuff to it. Well, how does that come into play? I mean, and what portion of it, what if you use AI to generate the new and unique and non-obvious stuff? How much of it can you claim versus AI?
All right, so that's multiple questions there. So why don't we try and hit them one at a time? All right, so the first question is, you mentioned, people reviewing the patent databases to see what's new and interesting, and then they want to go and add their own new and interesting things to further the state of the art. That's a normal part of the process, whether you're reading patents or research papers. You can kind of think of a patent as a research paper that's been slightly modified to comply with the legal standard for patents. So reading research papers, reading patents, and then adding your own innovation on it is a normal part of the scientific process. All right, so that's normal. Then the next question you had was, let's say they use a generative AI like ChatGPT or Llama or another one of these models, and they ask the model to take as an input, this innovative technology, and then modify it a little bit further, generate a new innovation. And then the question is, okay, we're there. And then the question is, now that we've done that, can we file a patent on this newly generated innovation? All right, so let's think back for a moment. If we go back to the days of Abraham Lincoln, over 150 years ago, when he was filing his patent application, he probably had to write it out by hand, right? They did have printing presses back then, so, eventually when the patent was released, it was probably printed, but the submission he made was probably by hand, handwritten documents. Because obviously they didn't have typewriters back then. But, we've had typewriters for a long time, had typewriters since early 1900s, right? And we've had, and people have been typewriting patents since then. And then we've had word processors since the 1970s, and we've had, Microsoft Word and WordPerfect and numerous other text documents that people have been using to create patents. And now we've started, add capabilities like spell check and templates. And so the patent documents themselves, we've been adding in various pieces of technology to automate and make the system more efficient. And that's been okay all along. So the question is, when is Gen AI doing so much that the human involved is no longer considered the inventor? And the answer is, we're probably not there yet. Probably, we can't really say a Gen AI created that invention. Probably it's a user giving a prompt, the Gen AI is responding to the prompt, and so the question is, how detailed a prompt do you have to give so that you are still considered the chief scientist on the project, and the work of the AI is just like a general worker bee or lab bee helping you out on a project that you conceived of. And so long as you can show that the human inventor actually was directing the project and doing a lot of the work and designing the prompt, that's probably enough to constitute a human inventor. Now, the patent office will not give a patent to an AI inventor. So if the belief is that AI created it, then there won't be a patent. But so long as you can show a human directed it and designed it and so forth, then that would probably be enough to grant the patent to the human who's involved. Was there another question?
Sorry, I don't mean to poke at that, but a couple of years ago there was the photographer that dropped his camera and the monkey grabbed it and took a selfie of it. And there was a lot of conversation about who owned the photograph. So I was wondering how that affects what you were just saying.
Yeah, so who should own the photograph or who will own the photograph is a different question. I mean, I personally have the opinion that the monkey should own the photograph, but U.S. copyright law doesn't recognize monkeys as owners of photographs. So I think in that case, you could argue the human does own the photograph. It was his camera, and the monkey was his assistant. Generally, what a patent includes is what the invention is, how to make it, stuff like that. The description of it, why the invention is better than the prior art, what was the improvement you made, to make it really clear. All right. Now, most inventions are actually a combination of two older inventions. The intermittent windshield wiper is really a windshield wiper plus something to make it go intermittent. So it's two things combined together to make it work. One of my favorites is peanut butter and chocolate from the Reese's peanut butter commercials. You have peanut butter and chocolate, they're both well known, combine them, you get something new. And that's why we think it's fantastic. I would say almost all inventions these days are some combination where you're combining something, a couple old things in combination. It's a new combination, and you get a patent on the new combination. Now, you'll hear people who are in the patent industry talk about all different types of patents. So I'm going to just mention this briefly, but it's not that important. There's provisional applications, which are like a temporary placeholder, and then there's the actual patent, which is called a non-provisional. And most of them are utility patents, which are focused on functionality, but there are something called design patents, which is kind of similar to a copyright or a trademark. And the design patent is kind of a design, an exterior design of something. And there's also international patents and so forth, and various other things I'm going to skip over. One of the famous patent lawsuits a few years back, almost 20 years now, was $600 million for the BlackBerry, because BlackBerry got sued on some patents by, and so Research in Motion had to pay $600 million to NTP. Steve Jobs himself was a named inventor on more than 300 patents, including a lot on the iPhone. And actually, the iPhone is an example of overlapping IP rights. It's got trademarks on the iPhone, Safari, Apple, iOS, and so on. Over 200 patents on the iPhone, dealing with the touch screen, the power, and so forth. There's copyrights for the software code, and there's trade secrets, which are secret, of course. But that would be stuff like customer lists and things like that.
So if there's a trade secret
the formula for Coca-Cola, and I don't know what that is, but I independently make my own formula that comes really, really close. I've not infringed on their trade secret. You can't really infringe on a trade secret.
Correct. Yeah.
So we're just saying, so as a tech company, some things I would want to keep as a trade secret because I don't want anyone else to know how I'm doing it, but then I can't, it's not protected.
The protection it gives you is, let's say one of your employees leaves and you kept it trade secret. Now, a very typical thing for tech companies is customer lists and customer information. You know, if it's private customer information, you might keep that as a trade secret, and then when that employee leaves, they're not supposed to bring it with them. Or proprietary software, that's another example of a trade secret. They're not supposed to bring the proprietary software with them. The government equivalent of it would be classified information. You know, when you leave the government, you're not supposed to bring classified information with you.
I had a question based on something you touched on before. So Big Pharma uses Gen AI to come up with things that to come up with potential, right? That would take them forever to figure out, right? So they don't really know how they're doing it. They just, here's some potential ones, right? And so let's say they hit on one and they make a lot of money off of it, and I'm sure they do their thing. So it's not that the Gen AI thing can be classified as an assistant, or maybe it can be, but it's interesting to think, just maybe it's because of its inanimateness and non-sentient part that's like, yeah, it's under that chief scientist who is a human.
Yeah, I mean, the way I think about it, and again, I mean, obviously there's a lot of debate and argument over everything I've talked about, okay? So don't take anything I said as gospel. Remember, this beginning part of the lecture was this is not legal advice, it's just general comments. But I think that, well, first off, if you want a patent, it has to be created by a human, because that's the way our laws are written. AIs don't get patents. So if you look at it from that perspective, then you have to ask yourself, if I create this model for pharma to generate all these different variations that we'll look at for research, obviously I put a lot of time into creating that model. Obviously I put a lot of time into creating the prompts that generated that output. And so the question becomes is that enough to say that you are the designer of these candidates or not? So, and I think there's a question in the back.
Yeah, I have a couple small questions and just some certain things I want to validate. So like a large language model is just sort of like a set of mathematical weights. So in and of itself, those cannot be copyrighted, right? Because they're like anything that's a mathematical fact or scientific concept, those things are not protected in U.S. law, correct? That's the first thing.
Yeah, so, well, okay, so let's back up for a second. All right. General concepts can't be copyrighted, all right? The only thing that can be copyrighted is an expression. So let's say I created a math book, you know, Algebra 1, okay? And in my Algebra 1, I've got, you know, x equals y plus 1 or y equals x plus 1. I got that little formula in my algebra book does have a copyright. You can't copyright my algebra book without violating my copyright. You can go and write y equals x plus 1 on the blackboard and not infringe my copyright at all, okay? You could even be holding my book in your hand when you copy it, but in that case, it gets to that fair use doctrine, because if you're literally copying out of the book, you're taking the formula from my book, and that's copying. Now, if you independently write y equals x plus 1, you don't have to worry about my copyright. It doesn't matter. So if you're independently generating your model and you're not copying someone else's model, you have nothing to worry about. Copyright is to prevent you from copying others' work.
So getting back to the question about what is learning and like what is the scope of the law in terms of machine learning and AI training. So if you had a foundation model, say, that was trained on music and the music was copyrighted, but then let's say it's onerous to just recreate a foundation model because it's such high cost. You found a technique that could, in theory, remove elements of the network that were influenced by those pieces of the copyrighted material. Could you speculate on whether that would ever hold in court? Like, what kind of argument would people say one way or the other?
So, all right, well, let's start with the easy argument, and then we'll go to the harder one. So the easy argument you could say is once you removed or isolated those elements of the network, so the part that was trained by the copying is no longer relevant, you could say at that point, you've stopped benefiting from whatever copying you did. So, if there's any sort of punishment to be had, if there's any damages or infringement, you could say the infringement ended there. So that's the first thing you can do as a benefit is you could say, maybe we infringed for a little bit, but now we stopped, okay? So obviously that's a good thing to do. If you've done that, you can just, that way you can use that as a potential defense. Hey, we stopped at this point. Now again, it doesn't deal with the stuff you did earlier. Maybe there will be damages for that, maybe not. But it does at least show that you stopped, okay? Now, to get to the harder part, which is, does that cure the problem? Maybe, depending on, how significant it was. Maybe if you can show you stopped, that'll be enough. Maybe not.
One follow-up. So if your model generalized aspects of, let's say, musical tempo or whatever, I'm just using that as a concrete example so we can reason about it, but you remove the subnetwork, but it's now learned some aspect of music that is not necessarily connected to any one copyrighted material, but it's something that was learned in the process. Would that learned aspect also have to be removed, those networks, if it's not like directly, like when does something become like a motif of something, and when is something is literally, it's sort of related to the transmutation notion that somebody else mentioned.
So, well, let's take a step back for a moment, and then we'll dive directly into your question. So remember, we're talking about a training model. We're talking about you've got copying potentially done at the input side and copying potentially done at the output side. On the output side, it's when you've generated an output that looks identical or very similar to what was alleged to be copied on the input side. So if you remove the elements you were talking about removing, but you still have some lingering training in the system at the upper level, and then your model goes and makes an output which is identical to a copyrighted work, the argument would be made that you didn't remove everything you were supposed to remove. So that's the argument you would face. But if you're not producing any outputs that look like the copyrighted work, maybe you could successfully argue you removed everything you needed to.
So like the opposing side could like literally hire a bunch of people that say, we prompted it like 1,000,000 times and like, it never showed up. But that's not like definitive, but they could continue hiring like labor to say, yeah, let's just continue prompt because we want to sue this person eventually.
Well, let's talk about what's actually going on in a lot of these cases. In a lot of these cases, you've got content creators who know their work is being copied to train AIs, and they also are seeing outputs that look a lot like their work. And therefore, they're suing. Because these AI companies have lots of money, and they feel like the AI companies are making lots of money off their content, and they're not paying them or licensing their royalties. One of the things I think we're going to see is some of these large AI companies outright purchase content companies so that they can get full access to all the content without having to spend lots and lots of money on licenses and lawsuits. So, question?
Yeah, so Cory Doctorow has coined a term that has to do with the kind of degradation of quality in platforms as value is extracted from users. And I think about patents and patent systems and patent development systems. Is this seen as a concern, the use of generative AI to develop new patents? Is that seen as a concern for patent people that practice patent law such as yourself, or is it an opportunity?
One comment I'll make is that the U.S. Patent and Trademark Office has actually been asking that same question recently. They've had a number of listening sessions, both in person and virtual, where the patent office was interested in stakeholders in the patent system, inventors, patent attorneys, organizations that own patents, would come in and comment on how they foresee AI impacting the patent system. So you can actually see some of those materials on the internet if you visit the Patent Office's website. My personal opinion is I look at it more as an opportunity than a concern. I do think, I'd say probably 80% opportunity, 20% concern. I do think there's a lot of potential for productivity increases, a lot of potential for improvement in work products, reducing inconsistent terminology, doing better searches of information, finding the best information, making it available, helping the patent examiners to find the best information so that they can produce better patents. Because really, if you think about it, a patent is almost a give and take process between a patent applicant and a patent examiner. The patent examiner who examines the patent has to give feedback to focus the legal rights of the patent on exactly what the inventor invented. And so you get better patents as a final output of the process if there's a lot of give and take between the two. So the more tools we can give to the patent examiners to provide a better examination process, the better the final resulting patents should be in terms of clearly explaining what the legal right is. So I think there's a lot of advantage and upside. With some minor concerns with how are we going to deal with the question of when is an AI creating something and when is a patent inventor, a human being, creating something, getting back to our human in the loop versus autonomous. I do think that there's going to be a human in the loop for a long time to come. I mean, going back to C-3PO and R2-D2 were on my first slide, those were both human beings wearing costumes. So we're not yet at having robot actors, but robot actors are coming, but they're not yet there. Another question?
We got a guy over here. Hey, I work in government contracting, and intellectual property is a major component of contract administration. I just want to generically ask your opinion on the future of AI in that realm, data rights negotiations, proprietary data, things of that nature, litigation related to AI and contract administration. Your thoughts just related to that? Nothing specific.
So I think that contract administration, again, we're dealing with lots of documents, lots of terminology. So I think AI will help to make sure the terms are consistent across multiple documents. And that'll help get rid of some of the lawsuits that have been over when the terms are slightly different. So I think it'll be a benefit there. I think data rights are going to be increasingly important because as we are in an increasingly connected world, we're going to be able to search and find literally everything. Like right now, I don't think anybody in this room could figure out who my first grade teacher was. But 10 years from now, I think anyone in this room would be able to type in a question, ask who my first grade teacher was, and get an answer. And so data privacy and data rights are going to be really important in the world that's coming.
Hi, thank you for the session. This is related to IP. So I just got actually an email about the U.S. copyright. They said that in many circumstances, AI-generated outputs will be copyrightable in whole or in part where AI is used as a tool and where a human has been able to determine the expressive elements they contain. My question lies, however, simple writing, the prompts that people use to query AI models likely will not satisfy these criteria for U.S. copyright. So my question is, do you see a world in which AI, like basically prompt for AI images, video, I work in the entertainment field, would be copyrightable in the future?
So let's back up for a step. To answer the first part of your question, so if you write a prompt, technically that's copyrightable. The prompt itself is copyrightable. Now then the next question is the prompt just by itself enough to copyright the content that's produced under the quote you just gave. And I would say it's really going to depend on your prompt. As we were talking earlier when I showed the example prompt that attorney wrote, if you write a short, very general prompt, the argument will be that actually that output came from the model, not really from your prompt. If you write a detailed prompt, however, I do think the detailed prompt would be sufficient to cover exactly what you're creating. So if I say I want to see a cat in outer space, and they show me an image of an orange cat with a rocket ship and the moon and the stars behind me, I didn't really list all those expressive elements when I just said cat in outer space. On the other hand, if I say I want to see my orange cat who's named Mary, as in Merry Christmas, if I want to see him, and I describe him explicitly, and then I explain I want to see, a NASA ship in the background, I want to see the Milky Way galaxy, and I go into detail on what I want to see, then I can claim, yeah, I've identified all the expressive elements in this illustration, and my prompt should cover it from a copyright perspective. And I see there's another question in the back.
So this, in fact, it was right after this symposium. I went on to, I think it was OpenAI, ChatGPT, and I had it write me a song. In other words, write the lyrics, right? I gave it a bunch of prompts, and it came back with the chorus and different verses. I took that as input to another tool that could create the lyric or create the music and the voiceover, and it actually sings the song for me. I went to a third tool and generated a dozen or more images that kind of matches the theme. And then I put all that into a mixer and created about a 2.5-minute video, if you want to call it, but it's static images that are changing as the music changes. I threw all that up on YouTube, copyright 2024, and just put that on there. I had a lot of people come back, you can't copyright AI-generated stuff. And I said, well, maybe, but the expression I should be able to copyright. The fact that I took all that and bound it together, was that a correct assessment or assertion?
Yeah, because what you produced is a compilation. Whether or not individual components, but once you're copyrighting the compilation, you're not copyrighting those images necessarily, unless you also created the images. But yeah, you could assert copyright.
Well, the images were created by an AI based on my prompt.
Well, in that case, but you can definitely copyright the compilation. I have no problems with that. And even the individual images, depending on your prompts, so long as they're detailed enough to get by the quote that we just heard a moment ago, they should be fine as well.
Of course, as you probably know, you can give an engine the same prompt. It'll give you two different outputs, based on what it's hallucinating at the time it generates the output.
Yeah, it's a probability distribution. Yeah.
So. I have one more question. So with regard to if you just simply prompt something and it's very general, you can't do it. Can you write a template for a prompt that would ask an exceedingly large amount of questions and routinize that process so that your end user could generate? Would that still be okay, or is it the fact that it's routinized in a programmatic matter go against it being potentially copyrightable?
I think you could. I think I'd have to, again, the question is, are you actually designing this? That's really the question, right? Or are you just throwing a random dice and getting a random output? So long as you're actually designing it, they're going to give you the copyright. If you're just getting a random output, not necessarily.
How much evidence do you have to keep in order to prove, if you're sued, that you have done it with enough iterative human in the loop?
Let's say that you are, we'll make it simple. You've decided that you want to use prompts to create the next great novel. And your next great novel actually looks a lot like someone else's novel that's in the bookstore. And so now they want to sue you, claiming that you have copied their novel. So the question is, how much evidence should you keep to deal with that problem? All right, so this is actually, you probably don't have to worry too much about this, because typically what happens is if an author sees that an AI is generating something that looks like their content, they're not actually going to sue the other user. They'll sue the other AI provider because the AI provider has a lot more money. So they're likely to go after the AI provider before they go after a user that infringes the content. All right, so that being said, if you're the one producing the model, that's when you have to worry about it. Now, one thing I would recommend, though, is if you are going to be doing a lot of AI-generated work, you probably do want to just go ahead and maintain a file of your prompts and the outputs, both from a perspective of just to, as a double check in the future, just to be on the safe side, but also just from a workflow management process. If you create something great, you're going to want to be able to go back and replicate it, perhaps. So, and nowadays the storage for a Word file or something like that is pretty minimal. So it should be pretty easy to keep track of the log files of your prompts.